Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. Again, it's Friday, February 16th, 2026 at 1:10 in the afternoon. And so we're here to take a look at a walkthrough of H674, which is an act relating to the creation of the Vermont Assisted Faith Program. So today we have legislative counsel Rick Sago with us. Going to walk us through the bill. Rick, welcome. Thank you for joining us.
Thank you for having me. Rick Sago, Office of Legislative Counsel. So H674, introduced by, looks like most people on this committee. That didn't count, but I see a lot of your names there. This is the work product of the sister state working group that was created in 2024. Some of you were here, some of you weren't here. That was Act 132, which I had pulled up and I can show you at some point. That bill, as it made its way through the General Assembly a couple years ago, was going to create this committee. It was going to actually, we had the language, it was going to be done. And then there was a decision to turn it into a working group to make sure it was done correctly, or as best they can, right? Plan it out correctly. So the working group and Representative Vice Chair Granning was on the working group, so she can provide any details, but the working group did produce a report a couple months ago that this bill is largely based on. 95% of the bill is based on the working group's recommendations. If there's something that the working group did not anticipate in this bill, hopefully we can hear about it. But my goal in drafting was to match the working group's recommendations. So this is, again, H674. We'll start with the bottom of the first page. This is the Vermont Sister State Program. It's going to be housed in the Agency of Commerce and Community Development. And that agency, you're going to see here, this agency really has quite the vital role in managing the program along with the committee. Subdivision 2, the purpose of the program is to strengthen Vermont's international engagement and to foster mutually beneficial relationships with subnational governments abroad, with the goal of promoting cultural exchange, economic development, educational cooperation, and diplomatic collaboration. That's the kind of overarching purpose there. Subsection B, program oversight. There's going to be a sister state program committee, which is made up of the following people to oversee the program: the ACCD secretary or designee, a member of the House appointed by the Speaker, a member of the Senate appointed by the Committee on Committees. And let me take a step back. A lot of these people were also on a lot of these offices were in the working group as well. So there's going to be some continuity, you would presume. The letter D, the chair of the Board of Trustees of the Vermont Council on World Affairs or designee, the Vermont Adjutant General or designee, the chair of the Board of Trustees of the Vermont Arts Council or designee, 3 members, 1 with experience or expertise in cultural exchange or in Peace Corps operations appointed by the governor, 1 member representing private higher ed appointed by the Committee on Committees, and 1 representing public education higher ed appointed by the Speaker. So that is 3, 4, 5, 6, 7, 8, 9 members total. Members of the committee shall serve 2-year terms. However, those 3 at the end, the 3 appointed by the governor, the Committee on Committees, and Speaker, shall initially serve terms of 3 years each to establish staggered terms. That was recommended in the report. I actually don't know if it's necessary. It's up to the committee if you want to do that. You're going to have some carryover with the secretary being there, the chair of the board of the Vermont Council, and the adjutant general. So it was recommended. I put it in there. But one thing I'm thinking about here is these 3 members. The governor's appointee, I think, is not going to be the issue, but the Committee on Committees, 3-year term, that's in the middle of a biennium. That could be an issue. Not a huge issue, but just something I was thinking about earlier when I read through it.
It doesn't, it's not intended to be someone who's serving in the body.
Right, but I always think about we're going through a break here, and I don't want that position to be empty for longer than it needs to be. But it's just the first time, the first 3 years, and after that, it's 2 years. So,
That's a clarifying question there. Is it, Eric, that with that, we're making a decision, this bill makes a decision for a committee on committees that has not, that's in that third year, that will be a different committee on committee comprised of different membership than it does in one biennium, that this is going to span biennia. So is that second committee on committees not getting to make a choice?
no,
Because the previous one did, and it carries over into a year.
no, it's just, and also there's going to be another committee and committees appointment earlier in the working group that will follow the biennium time period. This one here, because the first person is going to be 3 years, they'll have a midterm appointment, which is not a huge deal. It's just something.
Okay,
It's
it's a midterm thing.
every biennium will have an appointment, at least one appointment for a member. So
Thank you.
maybe it's me overthinking, but something if you think that's going to be confusing, we can fix it, but not a huge deal either way. Members may be reappointed. Subdivision 3, the committee shall elect a chair and a vice chair from among its members that shall each serve a 2-year term. A majority shall constitute a quorum, pretty standard language there. All meetings shall be called by the chair, but in the event that the committee does not have a chair, a meeting may be called by the secretary of ACCD or their designee. The committee shall meet at least quarterly for the purpose of evaluating current program agreements, proposing new program agreements, preparing its annual report, or discussing any other matter that the committee deems relevant to its work, and to review and score an eligible program application not later than 30 days after the committee receives the application from the agency. This will make more sense here in a second. We're kind of foreshadowing how this is going to work.
A rabbit trail, perhaps. But is there a general statutory allowance that speaks to doing meetings such as this remotely, via Zoom or something? Or does that need to be called out specifically here, or is there a blanket since COVID?
Allowance as far as payment, or how many times you can vote via Zoom?
Or just attend by Zoom and participate?
This would not have the same, the House and Senate each has their own resolution
Right.
that pertains to this that keeps getting renewed. That will not cover this, and there isn't the same restriction in place for these types of meetings. So if you wanted to attend via Zoom, I'm not aware of any restriction on this type of committee. It's not a legislative committee, right?
Right.
It's made up of some legislators, but it's not a House or Senate committee. So there would not be the same restriction on number of times you could vote
Okay,
via Zoom. I'll double check that, but I've never heard of any. Yeah.
thank you.
Yeah, because the restriction is through House rules for legislators.
Yeah. Okay, so subsection D. Think of this as kind of a roadmap and almost kind of a order of things, how this is going to work. That's how I wrote it, because there is this kind of procedural timeline that this process follows. So this is your program application review and approval procedures. We start with the development of the application process. So the working group suggested the Agency of Commerce and ACCD basically develop this process by which an entity can apply and be considered for admission as a partner to the program. This process shall include the development of an official application to be in the program, a confidential internal review procedure to be used by the agency to review applicants for sensitive political, legal, ethical, and strategic factors, minimum eligibility requirements to be considered for the program, a fixed scoring system, including a rubric to be uniformly applied by the committee to evaluate all eligible applications, and a memorandum of understanding template to be used and signed by the state and an approved program partner. So you can be more prescriptive there if you want the agency to consider more things. But this is kind of what the working group suggested the agency do when it comes to developing this application and the review process. Okay, good so far? So agency's initial verification, subdivision 2. So at this point, they've developed the application, they've developed this confidential review process, they've developed, all these things that they were told to do. When a program application has been received by the agency shall, before the committee may meet to review it, 1, verify that the application meets the program's minimum eligibility requirements, which remember they have come up with, right? They could be that maybe Rep. Granny can help me. What would be an example of a minimum requirement that the agency may set?
If there are 5 areas where we'd like to have some kind of positive interaction, education, economic, cultural, whatever you pick, meets 3 of the 5, right? You could say, something like that.
Right.
There are avenues for partnership, and that means that both sides win, because it's all about how do we create relationships where both sides benefit. That would be another minimum requirement.
This is why I demanded you be here for this testimony. 2, conduct a confidential internal review of the applicant. So this is, and more about this in a couple, I think, subdivision C here. This is your kind of more sensitive geopolitical analysis of a city, a county, some area that's not a national entity. And some of that information, some of that review, you don't want to be public about what the agency determines or how they determine that. More about that in a second. Subdivision B, not later than 10 days after this completion of this review, the agency shall send the committee a copy of the application along with a summary of the agency's analysis. So the agency may say this applicant did not meet the minimum eligibility, or they did not pass the confidential internal review of the requirement that we have set out. Subdivision C, the confidential internal review process, along with any and all documents reviewed during that process, shall be exempt from public inspection and copying. Again, this is sensitive stuff, and you want that analysis to be done, assuming it's going to be free from public inspection, Public Records Act. 3, committee review and recommendation. The committee, upon receiving an application that has received preliminary approval from the agency, shall meet to review the application not later than 30 days after receipt of the application. So remember, the committee must meet quarterly, right? That's one of the requirements. They can meet more than quarterly, but they must meet not later than 30 days after the agency says, we have this applicant that has passed our initial review. So the committee shall not later than 30 days after completing its review submit its final recommendation to the governor along with a copy of the application. The final recommendation can be 2 things. Either the committee recommends the application be approved, or the committee recommends the application be disapproved. They don't make the final decision, the governor does. But those are the 2 recommendations they send to the governor, is either thumbs up or thumbs down. Questions about that so far? Okay. So subdivision 4, the governor's review. The governor shall have the sole authority to issue final approval or disapproval of a sister state program application that the committee recommended be approved. The governor shall not review or approve of a program application that the committee recommended be disapproved. So the governor cannot go against a recommendation of disapproval. If the committee, I'll get to this in a second, the governor can say no to one that's been recommended to be approved, but the governor cannot say yes to one that's been disapproved or recommended to be disapproved. What's that? The governor shall send written notice of the governor's decision to the agency not later than 10 days after the governor's decision. If the governor disapproves a program application, the governor's notice shall include a written explanation as to why the governor did not follow the recommendation of the committee. Upon the agency's receipt of the governor's decision, The agency shall notify the applicant of the governor's decision not later than 30 days after the agency receives notice of the governor's decision. If it is approved by the governor, the agency shall finalize a memorandum of understanding between the state and the sister state program applicant. So that's kind of the timeline, the path. Are there any questions about that path or anything missing?
Just one of the things that we're talking about is if the application, should the governor even receive all of the applications? Shouldn't the governor only get the ones that were approved by the committee? Isn't that how we wrote it?
So you're suggesting the bill
We only send to the governor
that is recommended to be approved?
that are recommended to be approved.
So the current way, so on the top of the page there, subdivision B, the committee shall submit its final recommendation to the governor along with a copy. So right now, as it's written, the governor would get either one, if it's recommended approved or recommended not approved.
Yeah, I thought that the committee recommendation was that only the approvals go to the governor.
I may have gotten it wrong, Rep. Grandy.
May not have explained it well, so,
I mean, that makes more sense.
yeah.
The governor's not notified that the committee.
Which applications the committee even reviewed, only gets the ones that were approved.
Yeah. That makes no sense.
Yeah,
It's not like he doesn't have other things to do.
If he doesn't have the ability to override disapproval, then
then
no
why,
sense of sending it.
right,
Would he have the ability to be interested in it? Like, oh, it falls short, but I like some of these things. And I'm curious, the governor is curious about trying to get it across the.
yeah, I mean, there's nothing in this, we haven't gotten there yet, that says that you can't apply more than once. So if you get information that is, you're missing these, in these areas, you could always,
And not yet.
right? So if there's somebody in government that feels like a program should get approved, they should be working with that program to meet the criteria, because there's criteria. If you don't have criteria, what's the point of having a formal program?
Cool. Yeah, 3:00.
I think Edie may just have answered my question, but is there any kind of appeals process in the result of denial in the review process by the committee? And it sounds to me like it is improving your game and just simply reapplying issue.
Yeah, so in the procedures, because the task force worked on not only the, the thought of what the application, but also the procedure for how this would work. And in the procedures, there was that discussion of what kind of feedback anybody who doesn't get approved should get in order to help them understand where they fell short. So that would be something that is it a task force? Is it the commission, what is it called?
The committee, it's a committee.
The committee, that the sister state committee would come up with guidelines.
And so it's a permanent committee, right? Some else think this is in statute. This is not a temporary program. This is a permanent program that would be indefinitely operating. You could put a sunset on it if you want, but that's the idea, is that it's a permanent part of state government. Shall I continue? So is the committee on board? I should fix okay. All right, I will do that. Skipping down to page 7, subsection E, reporting. The committee shall submit an annual report on or before January 15th of each year to this committee and the Senate Economic Development Committee. That includes the following: an executive summary of key developments and outcomes of the program, a description of committee activities, including a summary of attendance and decisions at its meetings, updates on the program, including evaluation of sister state applications, new partners, significant developments, metrics of success, and challenges. Recommendations for new sister state agreements, along with the rationale for the recommendations and how they align with Vermont's strategic interest and capacity. a description of stakeholder engagement with the program, a financial overview, including a summary of funding sources and expenditures, and an outlook for the program, which shall include strategic objectives, potential new agreements, and growth opportunities for the next year.
Can you go back? Not understanding for recommendations for new sister state agreements. Isn't that what the committee does?
Yeah, so it would be updating in the report, it would list what the agreements were for the year. That's what it's supposed to be.
That's not a recommendation.
Well, it's what was recommended to the governor, I guess. But yeah, maybe it should be written differently.
So the way I read this, I think it's the way the chair reads it, is that this would be the agency saying that maybe an agreement with Tokyo or some other entity would be ideal. You'd be making recommendations for,
Oh, it's not the committee? Is this a report from the committee
this is
or
from the agency.
an agent?
I'm sorry, it's through the committee. I'm sorry. Make sure I get that correct. It is the committee that submits the annual report.
So it should be a list of the new sister state agreements and the rationale for why they received their why they were recommended, why, so these are the programs that we have, the new programs that the new sister states that
Yeah.
we now have and why we chose them.
So I think 3 may get to that, right? Updates on the program, including an evaluation of sister state applications, new partners. I could be more detailed on that, but
That's,
Well, and I
yeah,
think you want.
then maybe we don't need.
You
4.
may want the names of the new sister state agreements that have been signed, and you may want to know the ones that were rejected. Right?
Mhm.
And the reasons for the rejections and
So the report has stuff that the governor
That's all in free.
would get. The governor would learn about, I mean, because right, we're not sending the application or any evaluation to the governor except for the
approved ones.
approved ones.
Yeah.
Right.
And he can, and the governor can catch up on disapproved ones or anything in the report.
Correct.
Of course, he does have people that
Or on the committee, so
his agency, so
I was wondering if is that weird that employees of the agency of administration would be provided with information that they cannot share with the governor?
I think they can share it with them. It's just that they're not formally presenting applications for approval or disapproval because it's only approved ones that can go to it.
I understand. Thank you.
So I'm wondering if we should strike 4 because it seems pretty similar to 7.
7. So
Oh, yeah. As long as we're making
Yep.
changes, might as well make changes.
striking 4.
Because if 3 covers
Mhm.
evaluation of who the new partners are, what the significant developments were.
Yep.
Evaluating all the applications.
Yep. Again, we need rep grading here.
Right,
You know,
here,
Because we could have really torn it apart.
so what were they thinking? Well, this is what.
There was, an item about stakeholders are,
stakeholders are local entities that are partnering with these sister states to so there's no money in this bill. And part of the app.
Per diems.
There's per diems, there's no money to fund this program. So the thought is that, and every time you have, and I'm sorry, I'm jumping out of turn here, but every time you have a sister state, you have different kinds of get-togethers and gatherings and bringing words are so hard today. Bringing the public to these kind of events and so you need local stakeholders to champion those programs. And so that's part of the application process. Who is your local group that's going to be championing this? And how are they? And that's how it works well in other states. So that was part of the learning that Tim mentioned that we, when we talked about who we interviewed and what worked in other states and what didn't work.
At some point, does it require, are definitions advisable, or is that something that is tight enough that we don't need to, here's what a stakeholder is, here's what a state is. I mean, we're talking about different countries with different municipal political subdivisions of their states. Do we need to define those things at all, or is it okay to?
Which specific terms are you talking about?
Stakeholder was one of them.
We're talking about reporting here.
State was another.
Think of this as we're talking about reporting. So this is what you're going to get in your annual report. This is a pretty common phrase in statute, and I rarely see it maybe ever defined.
I wonder if it's
So I think it's
it's sort of vague.
right. Yeah, I think that's probably. So I don't think it needs personally. I don't think it needs to be defined, but of course you can always define something to be specific to what you want it to say.
It hasn't been elsewhere, and nothing's on fire because of it's not defined.
I can't say it's nowhere in these green books, but I don't. Yeah. Common term used. Okay. Any other questions about the reporting?
No.
All right.
We're gonna add the names of approved and any,
That's in 7, right? Or in
Three.
3, a combination of 3 and 7, I think gets you where you want to be. Do you want specifically have included rejected?
I think,
I think 3, evaluation of sister state applications, but I can say, the bill can say specifically, including rejected applicants, but.
I think you want to, I don't think you need to know the names of the ones that were rejected. If you get the report and you want to ask, you can.
Yeah.
But you can ask how many were rejected, how many were approved, how many were rejected, and then if this committee takes a look at the report, then they can ask those questions of, well, who were they?
Yeah. The compensation and reimbursement, this is your standard per diem language. You should know this by now. If not, I can walk through it. But subdivision 3, the money will come from ACCD. So you may want to make sure they're okay with that. Per diems do cost money. There's not a huge amount of money, but they do cost money. Okay, section 2 is a repeal. You may remember last year, this committee, S-122, I think it was. I forget the act number. I remember the bill number. 65, it's right in front of me. It's Friday. That was the economic development bill, which included the Vermont Ireland Trade Commission. This bill would repeal the Vermont Ireland Trade Commission. And the other 2 sections are the kind of incidental to the Vermont Ireland Trade Commission, the employment deadline, and then the repeal of the repeal. So it removes the Vermont Ireland Trade Commission is what this section does. And then the effective date is on passage.
And just to be clear, that's because a relationship with Ireland or any part of Ireland should be done through this sister state program and in a different way. The whole point is to set up a comprehensive way for us to have partnerships with other countries or other parts of other countries and not to have too many different outlets for that.
Is there another? Remember during last year, we looked at there was a body that I think included the chair of this committee that hadn't, as we formed in 2014 and hadn't met. Is that this one?
The International
Trade Commission.
Commission.
Yeah.
Did anyone contemplate eliminating that as well?
Eliminating, that's not in the bill. It can be an amendment to the bill.
I was wondering if the idea of streamlining had also reached that, and maybe this is more of a question for someone who was on the committee than for the legislative law.
I think it's different though. Although governor hasn't appointed anybody to that commission. We're talking about international trade, and this is more of
Not of the trash material.
different organization. I think, I mean, even though it's not working right now, it doesn't mean it can't in the future if you have a governor that wants, and if you have people that want to do it.
I forgot that as international trade, it's not the same thing. So, but in much more a way that the Ireland Vermont Trade Commission is more like what we're talking about here.
Yeah, I think trade from Ireland trade is a misnomer, but
I just wanted to double check. Thanks.
I think the Vermont Ireland Commission is more suited to be under the sister state. Any other questions for Rick?
The bill would take effect, I say this on passage, and that's to avoid, because the Trade Commission takes effect July 1st, 2026. So that was to avoid.
Say June 30, 2020.
Good. You could. You want to be cute? You could do.
It may not. If it doesn't get to the governor in on time, it could be after.
Yeah. You can amend that too. You can have it say June 30th or whatever day you want.
You could change the effective date of the Ireland Trade Commission.
You could as well.
Oh, man.
Those are
Do it all around here.
I can take a little bit of that headache, but let's not.
Thank you, Rick.
Yeah, you're welcome. Yeah. See you next week.
No. Thank you for coming in such short notice. We appreciate it. Helps us fill a little gap, and also those two reports that we got that you sent us yesterday, something that we're interested in. Appreciate your time.
Absolutely. Joe Valenti, Director of Policy, Department of Financial Regulation. And I think we have had DFR in committee every day this week, so I don't know what the prize is for that. But happy to be here. Before getting into the substance of the two reports, I thought I would talk a little bit about the process because that was the same for both. And part of why that's important is, as you know, we have been pretty busy over the last year. And Commissioner Sampson started in April. I started a week after him in April. And so, this was really the first, this along with the franchisor report we talked about last week. This is really the first time that we were involved in doing studies. And so we've tried to have an approach that is inclusive, that is efficient, that gets you the answers that you need. And if there are ways we can do that differently, I think any questions or feedback on that would be helpful. So for both of these studies that were in Act 23 last year, we were given a task, we were given a list of stakeholders, and in each case, we held 2 stakeholder calls on each of the 2 topics, one on suspicious transaction holds, the other on protections for victims of coerced debt. And there was a fair amount of overlap between the 2. So we really do thank the stakeholders for taking the time. I think in October, we had the second round of calls. We had both in the span of the same week. And so we know that it does take time on people's schedules to participate. But we aim to be inclusive. We wanted to hear all of the views and perspectives that were shared and to really have the stakeholders help direct the discussion for us. The suspicious transaction hold report, also the statutory language also had an interim status report requirement. So we did submit a brief status report on that back in November, and we had circulated that to stakeholders to make sure we were all more or less on the same page. And then we did circulate the final drafts to stakeholders. Those were in pretty narrow windows, just given the timing that we were dealing with around the holidays and preparing the housekeeping bill and preparing for session and all of that. We did limit discussion to stakeholders with the exception that were given to us, with the exception of people who had special expertise who the stakeholders thought would be useful. So in the case of suspicious transaction holds, we did have a speaker on our second call from Adult Protective Services. For coerced debt, we had speakers from the National Consumer Law Center who had studied this issue extensively. We see it as, in the reports we've sort of generated, I would say, ingredients or recipes, if you will. While one report was more controversial than the other, I think both of them still left some wiggle room and some tough decisions and weighing of pros and cons. And I think that's really an area where we expect the committee to review the evidence and make those decisions. We don't want to put our thumb on the scale sort of too forcefully in any particular way. We had broad consensus on suspicious transaction holds. We did not have consensus on coerced debt. Before I get into the details of those reports, any questions or thoughts in terms of process? Okay. I'll do suspicious transaction holds first. Like I said, this is an area where we had relatively broad consensus. I know this was something that was brought to the committee last year. Suspicious transaction holds in practice, what happens in many states, there are 26 states that have some form of a law around suspicious transaction holds. There is also language for, these are for transactions at banks and credit unions. There are also requirements in securities and the Vermont securities regulations, and also at FINRA, where someone is looking to make a transaction. Let's say it is a large cash withdrawal, and the bank or credit union or the broker dealer or whomever the individual is interacting with has the ability to pause that transaction for a period of time and enable the transaction to be investigated to see if it's legitimate, and also really to give the person looking to make that transaction a bit of a cooling off period. We know a lot of these transactions are the result of fraud or scams where someone is told that they need to transmit money or buy gift cards or buy crypto or do something urgently. And removing that sense of urgency is really important to safeguard their money, because while we do have protections, for example, for credit and debit card purchases, a lot of times when these transactions are done, they're final. And it is very difficult for the individual to get their money back. And if you are at a bank or credit union and you see this happen regularly, you'd like to be able to intervene. Just to give a sense of scale, the FBI puts out an annual report on cybercrime and fraud, the IC3 report. In 2024, they found that there were 937 complaints to the FBI by Vermonters around cyber fraud, over $11 million in losses. There are some studies that say that these numbers are vastly unreported because there are people who do not go to law enforcement. One of the things that has come up in research is people will, even if they may not go to law enforcement, they may go to their financial institution. That is a trusted place for them to work through the issue. Of those 937 complaints, 243 were from Vermonters age 60 or older, so that's roughly a quarter. It's hard to make conclusions on that because people aren't required to give their age when making a complaint. And there are valid reasons why people may choose not to do that. So we don't know how many were actually coming from older Vermonters, but older Vermonters, 60 plus, reported over $4 million in losses. So about roughly a quarter of the total, but over a third of the losses. What we've seen here in other states is that financial institutions have a role to play. They're trusted. They're on the front lines. They're able to interact with a customer when one of these situations comes up. And while the group did not agree on every single component, I think there was a broad consensus. Our recommendation is that banks and credit unions should have the general discretion to place a pause on a potentially suspicious transaction, and they should have some degree of liability protection associated with that. That is, I think the liability question is subjective. I think that's one of the things that this committee would need to figure out in the scope of a bill, and that's something that different states have taken different approaches on. In terms of some of the specific questions that were in the statute, which financial institutions, there are states that go beyond banks and credit unions and will include money transmitters, include non-bank lenders. Some of them, Virginia's does cover insurance. We did not do a thorough scan on insurance, but that's often a category that's not covered. We see banks and credit unions, though, really as a starting point for this. In terms of who would be potentially subject to a transaction hold, one thing that came up immediately in our stakeholder discussions, and this is an outlier relative to the laws that are in place in other states, but I think is really important to note, is that these transactions can affect someone at any age. And if you look at the FBI numbers, right, assuming that if everybody did report their age, if you have about a quarter from age 60 plus, that would mean 3/4 were under 60. And if you look at the FBI report, there were many categories of cyber fraud where people incurred losses through these transactions, where the majority of the people filing complaints were under 60, sometimes even under 50. And many of the state laws that are currently in place, the protection only kicks in at age 60 or 62 or 65, unless the person is disabled or has an infirmity or something like that. And so we really do see the importance of having something that's broad-based in terms of age and not overly specific in terms of what makes a transaction suspicious. Scams and fraud evolve frequently. There are some characteristics, some signs that a bank or credit union employee may be able to distinguish, but there's no sort of single pattern. And if there were, it could change over time. In terms of who else would need to be notified, there was a back and forth in our conversation about the use of trusted contacts. So this is a very common practice in other state laws. We also see it in securities, where the account holder can name somebody else. It can be a family member, a friend, a neighbor, who should be contacted in the future if there's a problem with the account. And the idea there is, in one of these scenarios, someone walks in, says they want to withdraw $10,000. There's a hold placed on the account. The bank or credit union notifies the trusted contact, and that trusted contact can then either they may be able to validate it and say, this is legitimate. They may also be able to, interact with the person who is trying to make the transaction and say, hey, I really don't, this is not what you think it is, and can sort of help them understand the nature of it. And that's, that can work really well in practice, but there are other scenarios where the trusted contact may be involved in facilitating that transaction. We had heard similar things about powers of attorney. There are many cases where having an individual with a power of attorney is incredibly helpful and powerful for people who need one. And there are cases where the power of attorney could be engaging in a form of financial abuse. And so we generally encourage the adoption of trusted contacts. We would suggest that those people be identified in advance, in a routine moment, if someone is opening an account or if they're meeting with someone about their account. They should also be revised periodically. And it is something that people should be able to update that, it may be that the trusted contact is no longer available or there's another person who's more comfortable. That does raise its own challenges, right? If you change the trusted contact to somebody else, then that person may try to defraud the customer, then that's an issue. So that is something that, we see as important, but not necessarily mandatory. We did talk about time periods, and states have put in various times for an initial hold and various procedures for an extended hold if there is a court investigation, an adult protective services investigation, if there's some need for court order, some need for additional time. We had suggested 15 to 30 days. We did not have specifics there. The number one thing that we had heard in terms of timeframes was just giving the powers that be enough time to do their work. If a hold is filed and Adult Protective Services is not able to make an assessment, that hold probably shouldn't be lifted until that assessment is complete. There was a question in the statute around notifications. We do think it is often appropriate for these incidents to be reported to law enforcement and Adult Protective Services. Our understanding is that often happens already. We did also suggest it may make sense to provide anonymous information on suspicious transaction holds, how often they're happening, where they're happening, to state authorities for tracking. We leave which authorities those are up to the committee. There was a question around access to funds in the account beyond that one transaction. Let's say someone has $15,000 in their account. They're attempting to withdraw $10,000 at one time. That's the suspicious transaction. In general, and stakeholders were in agreement on this, only that one suspicious transaction should be held, that people should have access to the remainder of the funds in their account so that they can pay bills, get groceries, do all of their day-to-day things. There was one comment we had received around other ways of preventing additional fraud, such as cutting off online access to an account. We don't have a position on that. I don't know, first off, how technologically feasible some of those methods are, and second, sort of how they were perceived or how they would work in practice. I think the idea that behind it is to provide some way of showing greater urgency and preventing, for an example, a third party from taking over the account in a scam or fraud situation. A couple other things that came up. One is we did suggest, under the catch-all of other issues that were raised, we do suggest that institutions that would be required to have a suspicious transaction hold policy in place train their employees. Our understanding is that already happens in most cases. There are many types of training already out there offered by AARP, offered by the American Bankers Association, regulators, others. And then we do have this immunity question, and it's a delicate balance because we want to make sure that institutions are not penalized when they are reporting a transaction that should rightfully be reported. There may be scenarios where it's an employee of the financial institution who is participating in or supporting fraud, unfortunately, and that is a scenario that we would need to have addressed. There are other situations where let's say the transaction was legitimate, and you have a customer who has been waiting for the down payment on their home, for example, to clear, or some major large transaction that's important, right? And they are frustrated with the bank for holding it. Now, I think that's a different scenario than what we have heard about in practice, which is someone engaging in a potentially suspicious transaction. That transaction is flagged, and then you have an angry customer who doesn't understand why they're not able to access their own money. I think part of the general risk in all of this is this is a way to introduce friction. Friction is important. It buys time to help resolve the problem. It buys time for investigations as appropriate, and it's an ability to safeguard someone's funds. We also have so many transactions that we engage in today that are frictionless. And part of the delicate balance here is placing a hold on a transaction and someone saying, oh, I'll close my account, or I'll do this another way. I'll do it through a non-bank payment app, or someone who is really desperate to make that transaction, it's still hard to intervene. But that's where he landed on suspicious transaction holds. So any questions on that?
So committee, the question for us is, do we want to go forward with putting a bill together to support this in Vermont? If we do, we can do that as a committee bill. You want to think on it and come back on Tuesday, we can do that, take time to read the report, but that's the question for us. What do we want to do with that?
Which report to be, like, would it be one committee bill that addresses what's raised in just one report or in both reports? I'm sorry.
The report that we just.
Just the one we just wrote,
one
yeah.
There's probably no more thinking that I'm gonna be doing between now and then on this issue.
Okay.
And I would, just from my perspective, I'd like to see a bill.
Do we want to do a bill that's going to help out people? Correct? I mean, that's the question. Who wants to say no to that?
And I'm not talking about the details and all.
Right,
Right.
right.
Once the bill, you're gonna know just about 30 different bills pieces of states that have legislation.
Right.
They might have all sorts of different takes on the issue. Not suggesting how we fashion the bill.
Yeah. No. But the question is do we want to move forward on a bill?
Yes. Anybody else?
I definitely would want to, I think if it's crafted properly, I think it really, one thing that comes to mind is usually these are first time transactions, and because of the nature of these fraudsters, they are constantly reopening accounts. So I think just flagging a first time large transaction with a company would help a lot. Just me, I'm thinking about how I can craft a bit, but yes, very supportive of it.
Yeah, $4 million in losses in my age bracket speaks to my heart. Let's see what we can do.
Yeah, I'm in favor.
Okay, so does anyone want to take the lead and work with Joe and some of the other folks that were on the committee to craft it, or do you want to think on that?
Be a part of that.
You want to do that?
Sure. Yeah.
Okay. Have you worked with Maria and Joe and Chris, and Joe can help with some of the other folks that were involved in? Great. Okay. We have another report.
Great. So moving on to coerced debt. This was one we had most of the same stakeholders. So the Vermont banks, the Vermont credit unions, Vermont Legal Aid, the AG's office, and the Vermont Network. I know some of them are in this room, and I really do appreciate their participation in our conversation around this. And I'll get to what coerced debt is and sort of what we went through in a minute. I will say this is an area where DFR is neutral. We did not have consensus on a bill, and we pointed that out in the report. This is a more emerging area, I would say, in that suspicious transaction holds. We identified 26 states. Coerced debt, there are 6 states that have laws with coerced debt protections. Most recently in New York, Governor Hochul signed a bill right before the holidays. So we were tracking this, right up until the last minute. And I will use the Donald Rumsfeld quote about unknown unknowns here. I think part of the challenge that I'll get to is just that because a lot of these laws are very new. There was one that was passed in 2019, and the others have all been in the last 3-4 years. there's not a deep track record for us to go on in terms of balancing the sort of positives and negatives. So what is a coerced debt protection? So if you think of identity theft, it's not quite identity theft. It's sort of a different category that kind of falls through the cracks in terms of the existing protections that we have. So the classic example for coerced debt is in a domestic violence situation where an individual is coerced into taking out loans for an abusive partner. It may be credit cards, it may be a car, it may be other things. There was a story published during the debate over the New York law last month that was about an individual whose partner had coerced her into signing a car loan under duress. She did not even have a driver's license. She did not know how to drive. And so the car was clearly not for her benefit, but she was dealing with the payments on this loan. And in many of these cases, it's either, you have someone who is dealing with the original creditor and trying to make payments, or it's in collections. It's tarnishing their credit. Tarnishing credit can make even things like finding an apartment more difficult. And so that's the sort of classic example, but we have seen these laws in some other states also address issues such as elder abuse. If someone is coercing debts upon an older person, it could be a younger person. This is something that has come up, for example, around youth aging out of foster care, where someone has been using their credit record to take out loans that or obligations that they may not have known about or have had the ability to contract. We have lots of protections in place for traditional identity theft. We don't have really easy ways of dealing with these situations where, as one state has defined it, where there's a lack of effective consent, that maybe someone did consent, but it was under duress. And so these various state laws enable someone to challenge a debt that they ostensibly owe because they were coerced into it, or it was a loan that was taken out without their consent, sometimes even without their knowledge, if their information was used by a partner or family member or others. And the challenge here is really a matter of scale and risk and, like I said, unknown unknowns. You could see scenarios where a large number of people see an opportunity to get out of paying a debt, and unfortunately, they take advantage of it. We had seen this, it's mentioned in the report, that there still is, federal law providing protections for human trafficking survivors to challenge debts, and completely well-intentioned, excellent regulations developed around it. And then there were incidents where people on social media had said, hey, you can get out of debt and raise your credit score 100 points by filing these forms and claiming that you were a victim of trafficking. No idea how widespread that had been or sort of how that had gone, but obviously there are falsehoods on social media that can circulate very broadly, I think, as everyone here in the room knows. And if you did have a scenario where you have a large number of people challenging debts, that could have a negative effect on banks and credit unions and other lenders and their ability to operate. Very similarly, if you have, even if it's not a large number, but you've introduced a new risk into the marketplace, that risk needs to be priced somehow. And is it through higher interest rates? Is it through scrutinizing borrowers more carefully when taking out a loan? Is it, not making as many loans? We don't really know. And I think the other side of this picture is what we've heard from advocates and what we've seen, in other states, is there are scenarios where it's a very limited number of people who take advantage of this provision, who are in dire straits, who may or may not be able to make payments on the loan anyway. And this is a loan that was going to be written off. And so that issue of scale is really the thing that we've struggled with because it is new. We don't have a ton of data to go on. And I think there's a trade-off to acknowledge that, there should be a process that is easy for survivors and that does not involve interactions with law enforcement and going to court. We know that those are known barriers. We want the people who need the help to be able to be helped. We need to balance that with, easy process with the challenges that lenders may face if, the scale for this upends their predictions for how markets would go. And we just don't, it's just an area where we don't know a lot. In terms of what we've seen in the other states, so 6 states have a bunch of different provisions. There was also a petition that was made to the Consumer Financial Protection Bureau in 2024 for them to look at changing the definition of identity theft to include the concept of effective consent. They received 50 comments on it from a wide range of stakeholders. That's all public record on regulations.gov. It's a very interesting discussion, very similar to the discussions that we had. But in terms of what states have done, all of the state laws have been fairly similar in that there is an ability for someone to challenge a debt. In Texas, it was done as part of their identity theft statute. They did not use the term coerced debt, but they did introduce the concept of effective consent. Varying states have talked about coerced debt. Others have also used the concept of economic abuse, which is someone unfairly controlling the finances of another person. One of the biggest distinctions across these states is what types of debt are eligible to be challenged. And Connecticut is the narrowest that we saw in our review of the 6, that it was unsecured credit cards only. And so that doesn't even include a student loan or a buy now, pay later or a personal loan or something else that's also unsecured. Connecticut's was also only for new loans taken out after the law went into effect. Someone could not challenge an old debt. So that's sort of the narrowest. There are other states where it is any type of unsecured debt. So credit card, personal loan, something like that. There are a couple of states that include various forms of secured debt. The statute that just passed in New York found an interesting way of dealing with this. If you're thinking of a secured debt, this is a debt where there is collateral, like a vehicle loan or a mortgage. And there are a couple of concerns that raises if someone tries to challenge that debt. One is, if the person still is challenging the debt and still has access to the collateral, then they're getting an unfair advantage, right? They're no longer paying for the car or the house, but they still have it, which that doesn't sound right. But the other is if it's a secured debt, it may be difficult to repossess the collateral or foreclose on it. It may be securitized. There may be other interests involved. So secured debt gets more complicated. The way that New York dealt with this, which was kind of novel, was that, let's say in the case of a vehicle loan, the woman I had mentioned earlier who was responsible for an auto loan despite not being able to drive, she were to challenge that debt, the car could be repossessed and she can't drive it. She has no interest in maintaining the car. We did hear from advocates that there were many cases where, it wasn't a vehicle that they could even use because their partner had kept the keys to it. It could be repossessed. And let's say if they were underwater on that car loan and there was an amount that was still owed, they would not be responsible for that remaining amount. but the collateral on that secured loan could be repossessed, and that was the way that they were dealing with it. There was also a provision in several state laws where if the victim is able to name the perpetrator, the person for whom they took out the loan, the creditor can go after the perpetrator for that debt. And so in some scenarios, it's possible the debt might have been written off, but now they do have someone that they can pursue for that debt, and maybe they might be able to collect on it. All of the sort of challenges to a coerced debt involve providing some type of information to the creditor or the debt collector, usually some type of a sworn statement that the individual provides and documentation. Most of the states we've looked at will accept a police report. They will accept an FTC identity theft report. They'll accept a court order. The one thing that is sort of important here and novel in a coerced debt context is that they will accept a sworn statement from a qualified third-party professional. And part of this is making sure, again, that victims or survivors have relief without necessarily going through the courts. The qualified third-party professional, depending on the state, it could be a counselor, could be a social worker, could be a physician. I think in some states it could be a clergy member. It can be someone who is licensed or trained to work with domestic violence or sexual assault survivors. And you can think of other people who might work with other populations, whether it's the youth or older Vermonters, who might also be on the front lines. And so they're submitting a sworn statement as well. And so that becomes part of the package of documentation. In terms of what happens when someone files in one of these states, if there's any collection activity, that ceases. The information is flagged on a credit report as being disputed. There's some type of investigatory process by the lender. And if the lender, through the course of the investigation, determines that, yes, this debt is coerced, then typically the person is released from that debt, and there's a request made to the credit bureaus that it be deleted. Now, I know we got into a conversation during the housekeeping bill about FCRA preemption. The Maine coerced debt law, which is the oldest in the country in 2019, was challenged on FCRA grounds. It was partially upheld. But FCRA and FCRA preemption are incredibly complicated. We don't have an opinion on exactly sort of what contours with regard to credit reporting agencies do or don't pass muster. Several of the more recent state laws, though, instead of making a requirement on the credit reporting agency itself, they put a requirement on the lender or the debt collector, the furnisher of the information, to tell the credit reporting agency either that it's disputed or to request that they delete it. I'm not an attorney, so that's not something that I can really weigh in too much detail.
Brief question.
Sure.
FCRA, that was upheld. That was a federal decision. It was a state. Where was that?
So FCRA, Fair Credit Reporting Act, is a federal law. The Maine law was challenged in federal court.
Which district?
I believe it would have been the Maine districts of First Circuit.
Thank you.
Sure. So and like I said, it was upheld in part, but that is always part of the uncertainty here. We did not opine on the question of changing the identity theft statute in Vermont. It is a criminal statute. Generally speaking, states that have passed these laws, and some of them, they have made it a civil violation for someone to coerce someone else to take out a debt. And that does enable the lender or the debt collector to pursue the debt from the alleged perpetrator. But we didn't want to get into sort of criminal matters here. There are many of the state laws that do retain all of the other abilities that a creditor would have to collect on a loan. and would enable them to collect from the alleged perpetrator. I mentioned with Connecticut, there was this issue of new versus existing, and a couple of the other state laws made that determination as well. Obviously, if it's for new debts, then that restricts the scope, and over time it would be a greater number, but it doesn't provide as immediate relief to survivors. Just two more things, and then I will take questions. One item that came up in several state laws was the presence of procedural safeguards. That typically you'll see the way these statutes are written, that the victim challenging a debt will provide contact information, an address, phone number, et cetera, and that they will request to only be contacted by those means, that contact information not be shared with the alleged perpetrator. There are a lot of other provisions we see in state statutes for an individual's safety. Similarly, there are situations in some state statutes where someone is not required to name the perpetrator if they are able to state that there is some risk of harm to themselves, their family pet, et cetera. There are some provisions in states for virtual court hearings and for privacy and confidentiality, those kinds of things. Last thing, not really the domain of this committee, but it's an interesting issue to think about. If a debt is ultimately released, normally when a debt is forgiven, that individual is liable to pay federal income tax on that amount. There are some exceptions. I know of a couple for student loans as an example, but there is this issue of someone receiving a tax bill in response. Obviously, we can't do anything about the federal side of it. I don't know about the state tax treatment, but that would be another wrinkle to consider in terms of the broader reaches of this.
Any questions for Joe?
This may or may not be something you can answer. Maybe it'd be better for Chris, but when somebody, I keep going through my head how this could be abused, I think.
Yep.
And I can see someone just racking up $50,000, $100,000 in credit card debt, saying, "Oh, I was coerced," and doing this over and over and over again. In the way credit reporting is done, does it show, like, if there is an agreement that's made where someone gets debt forgiveness, does it explain that? And what I'm trying to do is, can the bank at least assess risk?
Right.
And I mean, I know I'm hitting a touchy subject here, and it's a tragic thing, but there are a lot of people who continually get in these repeat abuse relationships. They either go back to that same person, or they go into abusive relationship after abusive relationship after abusive relationship. And I think it's a little unfair to ask the banks to take on that kind of risk when someone is a habitual offender, if you'll pardon the phrase.
So in terms of credit reporting, I don't recall all of the codes offhand, but typically there are different ways that debt. I think part of the challenge here that it's at the state level is I don't know how credit reporting agencies may respond to this, but typically, if you see a debt on a credit report, there are different flags or markers that, a debt may be paid in full as opposed to paid for, settled for a smaller amount or forgiven or what have you. And so, it is possible that you could see those items if they're deleted from the credit report, right? Then that provides a complication. But it's hard to know exactly how the credit reporting companies might respond to this, partly because of the newness of it. I will say one of the state statutes we looked at, I think, only allows someone to contest the same debt once. So that's a safeguard to make sure that it's not abused. I think part of this too is getting into the documentation requirements. And for example, if you're specifying who the qualified third-party professionals are, depending on, who they are, what their professional certifications are, it may be possible to ensure that some of these challenges are more legitimate. Another option would be if you were to just tracking aggregate numbers in some way. If it turns out that there is one person who has signed hundreds or thousands of these, right, then maybe that professional needs some additional scrutiny.
So I was a little unclear when the hold in these other states. When the hold is actually placed, is it when the claim is filed, or is it when it's been adjudicated by whoever is receiving that claim?
So there's usually an initial within 5 or 10 days, usually if the documentation is provided and filed, that the collection and any collection activity would cease, that they would not attempt to sue the borrower. They would and that they would notify credit reporting agency that the item is disputed. And then it was after the investigation, and some states will say that they have 30 days or I think 30 business days or a longer period. When the investigation is completed and they have a disposition, that's when a final determination would be made on the debt. One thing, again, not an attorney, and so I can't necessarily speak to the implications of this. Some of the states also had language about how that period would either be told or not told for purposes of a statute of limitations, because normally there is a period of time during which someone can be sued over that debt, and is someone placing holds to try to run out the clock? Right.
The reason why I asked between the difference, what takes effect when the claim is filed versus, I call it adjudication, or, you've looked at the documentation and you've made some determination, either that the claim was, not proper, or that it was. And in the latter case, you've had given people a chance and you've made a determination, yeah, this was a coerced step.
Right.
Where am I going here? Yeah, because I would have the same concern around, consequences on filing the claim itself. Not maybe the same level that you have, but definitely a concern. But when the claim has been adjudicated and it was really coerced, I think that's a different story. Now that doesn't answer the question of for the banks, I guess, of what they should do initially in order to mitigate that risk, I guess, right? I don't know the answer to that, but it just seems to me it's much more powerful when you've gone through a process and you've made a determination, hey, that's really coerced. And yet nothing's going to happen. They're still obligated to pay on a coerced debt. That's kind of scary too.
Yeah.
Emily? It's on screen.
Hi. One question. Did any of these statutes that you reviewed for other states include like recommendations for counseling or any kind of wraparound services?
Not that I can recall. It is interesting though, the way that some of the state statutes explicitly recognize the practitioners who provide those types of services as being eligible to file a report.
Okay, thank you.
Any other questions for Joe? So we have this bill already on our wall. So this is 385, I think. The one that you have a question?
No, I'm waiting for you to finish.
Okay, I can go back and get some modifications in there based on this report, based on what happened in New York, based on more input that we've had. And then I'd like to bring it back to the committee. We can actually discuss what the law could look like here in Vermont.
I would like that.
Okay.
I understand the concern about, the potential of of it being, I don't want to say abused, that's not, because when I think of this, I think
Not
it's
being
somewhat-
used for its intended.
Correct.
purpose.
And I'm thinking, even when I signed on to it, the thing that came to my mind was spousal abuse. And I just know the cycle, and it's too bad that there wasn't, and I don't know if this is even possible, but for cases where there is spousal abuse, some sort of, there needs to be intervention. And sometimes people that are in that particular situation don't, they need help. They need help with, processing, and I don't know if you can write that into the bill.
So, yeah, we would have to understand.
It's a very sensitive issue for me, so it's just the cycle just keeps going. And it would be nice to be able to say, and it would deal with that problem, is that, you're gonna get some sort of counseling on it. And I don't know how you would write that into a bill, but if you could.
Well, so we would want to understand what's already in law, right? And then it's really not our committee's purview. This is a piece that is our committee's purview. So that's a piece to recognize. Also, the fund, the victims fund is woefully underfunded. So the supports that are available in the state are less than they should be because we're not, so there are a lot of pieces, but we can get testimony on, a portion of that, probably not. But to understand what is available in Vermont for victims and what is going on. Emily?
Michael got to actually what I was going to say. I just want to second that point. If there's some sort of way that we can think, because banks are kind of, I mean, it's an interesting position that they're in because of the point that was made about them being kind of places of trust. And I think we're seeing so much more of this fraud going on. So I'm curious about how we might be able to put something in that would allow for wraparound services or recommendations or getting people further help.
I'm sorry.
Yeah.
If we're thinking around, ideas around the bill or anything like that, that piece around, what are the consequences when you just make a claim versus, actually getting a determination is important to me anyway. And it might narrow the scope of the impact, unintended impact on financial institutions if you pushed it more. Yeah, I don't know, 30 days, 10 days, I don't know, but I didn't say that to everyone, but maybe some attention paid to that issue.
Any other discussion on this? Thank you, Joe. Thank you, committee. Our chair is back. I'm going to turn the floor back over to him.
So first, suspicious activity. Everybody want to go forward with that?
Jonathan's going to take the lead. on
Okay,
that.
great. I think that Chris and Mariana, he's got some language that he's thinking about. See what we can come up with. Or step.
Do folks want to go forward with that? Is there anybody that on the first step though? Kind of saw nods, but I didn't go around the same way we did on the other one.
I'm happy to move forward with that.
We haven't had the language yet,
New language.
so language,
Right.
yeah,
Yeah.
so
So I'll bring.
we'll take a look at that and then we'll see what goes on from there. Okay, anything else? Great, Joe, thank you for, again, coming in, appreciate it. Thank you for the time and effort that DFR has given to all the reports that we've asked, but they are really helpful.
Thank you.
Yes, I know we asked for a lot of reports, but we try to start taking it more seriously than we have in the past. Thank you. Committee, I think that's it for today. I did, we did that before we go for lunch.
Great.
So you'll see the agenda will be posted tonight and I went through it with you before we go for lunch. So everybody have a good weekend, get recharged again. And we'll start back up Tuesday morning at 9.